Good evening. Today is Monday, August 1st, 2022, and this is a 108th episode of New Paradigms. I'm your host, Sargis Sangari. My honored guest today is Mr. Allan E. Parker Jr. He is the president of the Justice Foundation, and he is a former professor of law at the St. Mary's University in San Antonio, Texas, where he taught economic law and also civil procedures. He was also at the same time a visiting professor at the University of Texas and studied international human rights at the International Human Rights Institute in Strasbourg, France. He also taught international human rights at the St. Mary's Institute on World League problems and also in Innsbruck, Austria in 1992. Allan Parker was the lead counsel for the Norma McCrory, formerly known as Roe of Roe v. Wade from 2000 to 2012, and also at the same time, Sandra Cano of the Doe versus Bolton until 2014. He is here in an effort to discuss the issues of where we are going to be with the changes that have taken place now with the Supreme Court overturning Roe v. Wade and also ruling on Dobbs as to what the future of abortion laws will be in the United States. Before I bring him in, there's a short video on Dobbs specifically that I want to call him for now.
The doctrine of stare decisis, which requires that courts adhere to judicial precedent, is fundamental to the American judicial system. Nonetheless, since 1921, every Supreme Court justice has voted, at least once, to overrule precedent. Dobbs versus Jackson Women's Health Organization is another instance in which the court overruled its own precedent. Jackson Women's Health Organization, an abortion provider, and one of its doctors, brought a federal court action challenging a Mississippi law prohibiting abortions after 15 weeks of gestation, on the ground that the law unconstitutionally infringed on a woman's right to an abortion, as established in Roe v. Wade and Planned Parenthood of Southeastern Pennsylvania versus Casey. The federal district court granted summary judgment for the plaintiffs and permanently enjoined the law's enforcement. The Fifth Circuit affirmed. The United States Supreme Court granted cert.
Allan, it's good to have you here. Much appreciated, Mr. Parker, for being here. That kind of gives our viewers a little bit of an insight as to what's happening. I do know that it's been, 50 plus years of precedence almost. What was it specifically about Dobbs that really changed everything? I mean, there could have been these type of challenges in the past. Why is it that we were able to get to where we are today?
Well, I think there was a accumulation of outrage by the American people over the killing of infant life in the womb. Abortion is not a fundamental right. It's actually a crime against humanity, because even the Supreme Court has admitted that abortion, at the moment that an abortion occurs, an infant life is killed. And even the liberals on the court, like Ruth Bader Ginsburg, have admitted that abortion is a painful decision for women. So it is at a fundamental core a life or death decision. And we've had this desire in the past to help women, but we also have a desire to protect human life. And almost all the states have adopted safe haven laws. It's been hard to reconcile the two. But the Supreme Court has now said states are free to ban abortion if they want to, but even if you live in a state that bans abortion, no woman in America has to parent a child if she doesn't want to parent that child. Because of a new development of the law called the safe haven laws, every state allows a woman to safely surrender a baby at a designated place, usually a hospital or fire station, within a designated period of time after birth. It's usually 3, 30, 60, or 90 days after birth. She can turn over the baby to this, say, fire station with no questions asked, no cost, unlike abortion, it's free, and she can be free of the burden of taking care of the child for 18 years without killing the baby and without deeply traumatizing herself through abortion trauma. And so I believe we're moving towards a more just and humane society. Eventually, abortion will be as unthinkable as slavery and as segregation, both of which were once upheld by the Supreme Court and said they were in our Constitution. But we've changed, and now the Supreme Court is saying it's time to change for the better again. And just like when they ended segregation, there's a lot of segregationists who said segregation forever, segregation forever. And on the day of oral argument in the Dobbs case, on December 1st of last year, I was there, people were shouting, abortion forever, which was the old segregationist slogan. But in 1954, the Supreme Court reversed one of its old 58-year-old precedents called Plessy versus Ferguson. Segregation for 58 years. But it was unjust. It was a crime against humanity. It withdrew legal protection from a class of human beings. And so in 1954, they said, we are withdrawing segregation's protection. It took years to get a national law outlawing discrimination everywhere. And it may take that long. We're in a de-abortification of America right now. But eventually we'll become a society that says, don't kill the baby, don't hurt yourself. Give us the baby through the safe haven law, and we'll give them to the million families waiting every year to adopt newborn children.
Mr. Parker, from a legal perspective, is this just the issue of a debate on what a person is, or has that been settled by the courts, or is it an issue of just politics that people cannot settle on that particular question yet?
Well, the court did not decide what a person is, but the court didn't make a political decision. I want to make that clear. The court was interpreting the Constitution according to the meaning of the Constitution at the time it was ratified by the people. Why is that important? People say, well, that's old time. The ratification of the Constitution by the people of the United States that makes our form of government legitimate. We came together, we said, this is the kind of country we wanted to be. And abortion is not mentioned in the Constitution at all. There's mention of it. And at the time of the Constitution's adoption, abortion was illegal everywhere. At the time of the 14th Amendment, abortion was illegal everywhere in the United States. And abortion didn't become legal until 1973 when 9 people on the Supreme Court, and actually it was only 7 people, it was a 7-2 decision of the Supreme Court. They took the decision away from the Democratic caucus and they said, we think the Constitution protects abortion. But it was never in there. And when you see those pictures on the screen of just a few people, if you have a few people governing a country, that's called an oligopoly, government by a few. A monopoly is kind of government by one, or a dictatorship is government by one, but a small group of elites governing. So one of the attacks on Dobbs is, it's undemocratic. No, it's the closest thing to democracy. They turned the decision back to the Supreme Court. And in fact, they admitted their own as a court. They said, we were wrong as a court to make up our own rule. It was grievously wrong. It's for the people of the United States to decide at this moment whether or not the state should be allowed to ban abortion or not. So every American, by November of this year, every American in every state will get a vote on whether or not what they want the law to be, or at least on representatives. They can choose representatives who say, we'll go make a law protecting abortion, a representative, a member of the legislature who says, we'll go pass laws or keep our laws protecting life. So it's a big decision for America this November, but it's not a decision that the Supreme Court said they should make. say that's good for where we are right now. And though I will say our clients actually argued that there's a right to life in the Constitution because the word abortion's not mentioned, but life is mentioned. It says no person shall be deprived of life without due process of law. And so we believe you're a person when you're conceived in the womb. Human mothers, human fathers produce human children. A human embryo is a human being. But the court did not go there. Our group and others argued that. That's kind of the big debate going on in America right now. When does life begin, or when are we going to give legal protection to life?
Where do you see it from your perspective when that should be discussed? Look, if you're an individual, a grown human being, and then you are in an accident, and your brain stops ceasing functions, and you're dead, and you have a machine that is keeping you alive, you're still considered a person, although you cannot make any decisions on your own. Does something like that ever apply to what a fetus might be, regardless of when that fetus is? Because eventually that fetus will become a human being. Or has anything been broached by the courts that at least gives us an indication of what that definition may be? I mean, you're not going to take somebody who's brain dead and not calling them a person. Where does it begin where you start calling somebody a person, knowing full fact that that embryo is going to develop into a human being? And I guess my question on that other piece would be, I have family members who have had embryos that are sitting in a freezer somewhere. They are considered persons because they can develop into a person. Why is that not seen when it comes to abortion? Is it just simply politics that particular embryo that is being, in the process of growing, and a mother who is a carrier is just seen as something different, either politically, or is it seen something different legally?
Well, those are some very good questions and some very deep questions. So who is a human being, and when do we get human rights? Most people today believe, for example, there should be a right to life for every human. Well, when do you become human? I believe the scientific method is when you are a member of the species Homo sapiens. And what is a Homo sapiens? That's human. You have 46 chromosomes. You're a unique individual person. Every person that's ever conceived is other persons. It's amazing the complexity. And the average human adult has 70 trillion cells in their body, but it starts out with one cell. And that's when the sperm and the egg, the sperm of a man and the egg of a woman, come together, point into one cell, then that cell begins dividing. But the moment it's a cell, there's everything that is human in it. All the DNA, everything that they'll ever be is in that cell. And until the day all the cells die. So human mothers and human fathers give birth to human children. In vitro fertilization, I represented Hannah in the Dobbs case. One of the 4 briefs we filed was hers. She was the first formerly frozen human embryo to ever file a brief at the Supreme Court. What I mean by that, all of us are former embryos. That's how every human starts. That's the first stage of human development. Are you human then? Yes. Are you human when the baby's born? Yes. Are you human when the baby begins to walk? Yes. Are you a human at 3 years old or 10 years old? Are you human before you're a teenager? Yes. These are all just stages of human development. But the humanity began as a science method when all the DNA was there of a unique, living, separate human being. And the Eighth Circuit Court of Appeals upheld a South Dakota law that said a woman had to be told abortion is the termination of the life of a separate living human being defined as a member of the species Homo sapiens. And Planned Parenthood said, no, that's a philosophical question. Well, Planned Parenthood is a denier on this. because the court said there is plenty of science to show. It's not a metaphysical question. It's not philosophy. It's pure science. And even the abortionists usually admit today they're killing a human being. But what they tell the woman is it's just a mass of tissue. And that's a sort of half-truth, a misrepresentation. You could look at you and me and say we're just a mass of tissue. And in one sense, we are just tissue and bones. Now, but we're human. We believe the law should reflect that we're worth more than just the mass of tissue that we are. Otherwise, you can't have a law in a just society. Now, I also was in the park this morning with a statue of Franklin Delano Roosevelt. Many people consider him a great president, and most people at the time didn't know he was disabled and in a wheelchair. And today, if the scientists could tell he would be disabled, many people would abort Franklin Delano Roosevelt in the womb, and we wouldn't have had a great president like that. One of the things states are doing is banning disability discrimination, that you can't just say, oh, this child might be disabled and throw them away. That's the road to death and destruction. When you do protect the weak and vulnerable members of society, then anybody can be killed at the whim of the majority. That is the tyranny of the jungle. And we cannot have that in America.
Mr. Parker, I have a video I'm going to show real quick. It's a quick AP video, and it kind of looks at the historical issues. And then when we come back, I do want to close out with some questions as to where we're going to be going with what you think the states are going to look at, because all of them are making a different decision on this. So if you could cue that up, please.
There had been a handful of states that had liberalized their abortion laws in the late 60s and early 70s, but abortion really became a national issue when in 1973 the Supreme Court announced a constitutional right to abortion. Roe was the first time the Supreme Court spoke about abortion. Not only was it a major legal precedent, but it also transformed the issue into a huge political issue. By 1980, for instance, the Republican platform had a very strong anti-abortion plank calling for a constitutional amendment to ban abortion. It also spawned a series of legal challenges over the years, testing every aspect of abortion rights, including laws about informed consent, about notifying spouses, about waiting periods that came to the court in the intervening years. As the court became more conservative over the years, there was less support on the court for abortion rights, and what had been a 7-2 decision became basically 5-4 outcomes in later cases. Now, the second major case that the Supreme Court heard on abortion was in 1992, when the court actually reaffirmed the right to abortion in a case called Planned Parenthood v. Casey. That was a case in which the court actually upheld a number of state restrictions that Pennsylvania had passed, but at the same time, it talked about the importance of a woman's right to choose, at least until the point of viability, the point at which a fetus can survive outside the womb, which is usually around 23 to 24 weeks.
I wouldn't let you babysit my children.
In 2018, Mississippi enacted a ban on abortion after 15 weeks of pregnancy. But as the case developed and as the composition of the court changed, Mississippi and the anti-abortion movement decided to use this case as a direct assault on Roe and Casey. When people show up outside the court, when cases are argued or big decisions are handed down, the sidewalk in front of the court fills with people on both sides of the issue. In addition, there have been marches over the years, so there's a lot of political energy surrounding abortion. It's also an issue that both parties think that they can use to their benefit in electoral politics, and so we'll have a chance to see that in this year's midterm elections.
Mr. Parker, by May of this past year, before the ruling that was made by the SCOTUS, you had almost 600 abortion clinics out there that were operational. Some of those have, of course, closed or are not operational now, waiting to see what the states decide. 18 states have imposed a 24-hour waiting period. 6 states have looked at possible 72 hours. And then with all that said, you have restrictions as to what could be sent in the mail, by whom, when it comes to trying to help somebody have an abortion. Arizona, Arkansas, and Texas made abortion pills mailing illegal itself. And then you have almost 16 other states that require a physician to be there to provide that, which in cases would mean that they're trying to squeeze the possibility of not allowing any abortions to take place. With that said, again, is this just simply an issue of we're fighting with the 14th Amendment, what the concept of a person is, how the courts have defined it, or is it something beyond that, where you have states like here in Illinois, where I am, you're not going to see a change in state law, it seems, to protect the unborn fetus. At the same time, in other places, there's a bit more of a restriction. How is this country going to work through this process at the state level, given previous patterns of different type of rulings where the states eventually had to make the decision? And then finally, there was a federal that kind of codified everything that the states had decided to do.
Well, thank you. Again, that's a great question, and we have a great historical analysis, and that was how we ended segregation in America. And segregation was the law of the land for 58 years. It was declared to be constitutional by the U.S. Supreme Court. They declared that the African Americans were an inferior race, not entitled to equal protection. And so they said all they get is separate but equal. That led to segregation, and that was by the Democratic Party in the South, actually, that did that after the Civil War. The radical Republicans had ended slavery and preserved the Union. And when they left the South and took the military with them, the KKK came in place, the Democrats took over, and they basically segregated the African Americans. We know how horrible that was. So in 1954, the Supreme Court reversed its own 58-year-old precedent, even though the segregationists were saying segregation forever, and they stood in the courthouse doors and they said, this is the way society will always be. We've come to rely upon separation of the races. And they said, these African Americans, and they called them worse names, which I'm not going to repeat, they're not even human. They shouldn't get equal rights. Well, that's what people are saying about the humans in the womb, the children, the babies. Oh, they're not human. We're not going to give them legal rights. But the other thing, I want to say this, I represented thousands of women hurt by abortion in the case. I represented 2,249 women hurt by abortion who came to the court, and they're going to the legislatures. I was at a press conference with them today. The women who've had abortions are saying, please make abortion illegal. Don't hurt women anymore. Instead, tell them about the safe haven law. And you did a pretty good summary of the law in every state, except you left out the one thing everybody's leaving out. And I appreciate your having me on the show so these new viewpoints can come across. Every state has a safe haven law. In half the states, abortion will still be legal, but even in the states where it's not, the safe haven law is there. Drop your baby off at a hospital or fire station, no questions asked, no legal procedure, no money is exchanged. Unlike abortion, you don't have to pay $500, $1,000, $2,000 to get an abortion. It's free, the safe haven law. And the state will take the baby. And let me say this, we all have compassion for women. I do, I represent them. If you're low income in every state, the state will pay for your medical bills. The only expense of pregnancy is basically medical care until the baby's born. And at which point you can leave the baby in the hospital, walk out, say, I'm safe haven my baby, and be free to pursue college, career, whatever you want to do. And you don't have to have a good reason. You don't have to justify it to anybody. It's your right in every state to safe haven the baby. And so that's the government safety net, which should be available to everybody. And we'll basically say, give us your baby. What'll happen to those, there's 1 to 2 million families every year waiting to adopt newborn children. And a lot of them are people who tried IVF first. Actually, people don't know this, but 10% of American women between the ages of 15 and 44, the childbearing years, 10% are infertile. They can't have a baby after a year of trying. That's the definition of infertility. The medical reason may vary depending on the woman or the couple. Sometimes the man is not fertile, but she wants, to raise a child with her husband. So anyway, after about 6 million women every year can't have it, then they want to have a baby and they want to say, I'll adopt a baby. So this is the answer to America's problem.
Mr. Parker, one final question, and it has to do with what the cases have been in the past where the courts had ruled with the 14th Amendment specific. If a woman is the only person that can actually bring a child to fruition, create a human being, you think there's going to be any debate there between where does that right lie? Because as you said, if the fetus is a person, then that means that person is separate from the body of the woman who's carrying him. But then what are the legal rights that a woman has under that 14th Amendment where the court really hasn't been able to really clarify things for the various different states?
Right. The court declined to answer that question, and they said it's up to the states to decide it. Now, I think in about 5 to 10 years, there will be a right of personhood under the 14th Amendment eventually. The states may want to implement that right now. That's the states who are banning it, often base it on the 14th Amendment. No person shall be deprived of life without due process of law. So this is an argument that's going to be made, but even the practical arguments are, don't kill the baby, don't hurt yourself, give us your child. I think those arguments will be made because we want to help all women as well as save the life of the baby. I did represent Melinda Thibault, the founder of the Moral Outcry Petition, acting on behalf of 539,108 signers of Moral Outcry Petition. And the Moral Outcry Petition, which you can sign at our website at thejusticefoundation.org, you can sign it, and it has 5 reasons why abortion should be outlawed in every state. Before it was a petition to the Supreme Court, they've now reversed Roe v. Wade, which is what we asked them to do. Now we're going to say these are the every state should outlaw abortion. Number 1 is what you're saying. The 14th Amendment protects life. It's a crime against humanity to take away life from a class of human beings. Children in the womb are humans. So that's number 1. It's a crime against humanity. Number 2, it hurts women. You think you're helping women, but instead you're opening a doorway to pain and suffering. And recovery programs on our website. If you're suffering, it is a crime against humanity. It is a sin against God in many religions, but it's not the unforgivable sin. We are a Christian organization, but our arguments are based on law and science. But we help people because we're Christian. And we don't condemn people because Jesus Christ came, not that people would become, but that they could be saved from their sins. All of us have sinned. But if he said, for John so loved the world, if he gave his only begotten son, that whoever believes in him will not perish, but have eternal life. And as you said at the beginning, I represented Norma McCorvey, who was the Roe of Roe v. Wade. Every year on the anniversary of Roe v. Wade, she began to feel responsible for the deaths of 1 million children. Imagine that. But she heard the gospel and she gave her life to Jesus Christ, and she was forgiven for her sins, and she's now gone on to be with the Lord, in my opinion. And I knew her even to her death. She still had a sign on the wall that said, Jesus is my boyfriend, kind of meaning I love Jesus, he loves me. And there's forgiveness and healing through Jesus Christ for the sin of abortion, for any woman or any man that's participated in abortion.
Well, Mr. Parker, we'll see. Let's see what the states are going to do, and let's see what cases are going to make it up to the Supreme Court. Is there any cases that you think that are about to probably move through the pipeline that your foundation is right now looking at? What are you all looking at over the next probably year right now, looking ahead, given the fact that you've been involved so much, especially with the Dobbs case?
Well, right now, the abortion industry is on the run. They're dropping lots of lawsuits that they had in federal courts because there is no constitutional right to abortion. For example, just last week, we had a case. They had sued the state of Arkansas because Arkansas took the oral outcry petition, made the petition the legislative findings, and they banned abortion except to save the life of the mother. That case was on hold at the Eighth Circuit Court of Appeals because it had been stopped prior to Dobbs from going into effect. Well, just last week, the abortion industry dismissed their federal lawsuit. There is no more case. So there probably won't be a case going to the Supreme Court for at least 1 to 2 years, maybe 3. Instead, they're suing in state courts now, trying to find a state right to abortion in their constitution or just in their law. So a lot of the litigation is going to the state battle. The battle is now on 150 fronts. Instead of at the Supreme Court, there's 50 states, and the battle will be in the legislative branch, the executive branch, and the judicial branch of every state. You might have a state like Texas that bans abortion, but you have a prosecutor in the executive branch in San Antonio, Texas, who says, I'm not going to follow the state law. I'm going to become a lawless prosecutor and decide what I think the law should be. So you're going to have these battles all over the court and all over the nation. If I may just kind of close with this, we have free legal resources available to people on our website, the www.thejusticfoundation.org. We have free legal resources. Number one, if you are a woman who's had an abortion and you want the courts to know how much abortion hurt you, please go to our website. We have a project called Outcry Silent No More. You can give us your testimony. We'll protect your identity, and you tell us whether you use your first name, full name, or initial only. And we'll like in Dobbs, we gave over 4,000 testimonies. We're going to give those to the states now as they consider abortion. So you know how much abortion hurt you. Tell us so we can tell the courts at our website. The second is forced abortion is illegal, even in a state where abortion is legal. Today, the city of San Antonio said they want to protect abortion unless it's a forced abortion. And on our website, we have a Center Against Forced Abortion. It's all free for you. Download the Dear Parent letter. Parents can't force a girl to have an abortion. The Dear Father of the Child. He can't force his partner to abort his child because he don't want to pay child support or be a father. And then we have the thing we have there is the moral outcry petition. Anyone can sign a petition asking right now it says the Supreme Court, but we're going to change it to ask every state to outlaw abortion because every state has a safe haven law. No woman needs abortion to have the freedom to live her life the way she wants to. In exchange for a few months of pregnancy, which the state will pay for if she's low income, in exchange for a few months of pregnancy, which is serious, the state will give every woman 18 years of freedom from parenting and the expense of parenting. Because there's millions of people who think children are a blessing and they want those children in their families. So all that's on our website. We do everything at no charge because people donate to us. If you'd like to make a donation to support our work, there's buttons for that on the website also.
I much appreciate it,
So
Mr.
thank you for
Parker.
having.
No, it was a pleasure, and we'll try to get you back in again, depending on what the changes are going to be. But for our viewers, again, if they go to the QR code, as you all know, down below, is going to take you specifically to the Justice Foundation, and from there, there is, if you want to donate, you can donate to the Justice Foundation. And for us, for our viewers, so you know, we also United the Sunni Appeal. We raise money for the Christians of northern Iraq, and this year for South Sudan. with everything that they're dealing with. And again, much appreciated for Sim Productions for giving us an opportunity to be able to bring gentlemen like Mr. Parker to our discussion point. With that said, we're going to end the show with a video. And Mr. Parker, it was a pleasure having you here. God bless, and we'll see you in the future. This is New Paradigms.
Thank you.
In the 1970s, we had the Roe v. Wade decision in the United States. It was a decision relating to a woman's right to have an abortion. It introduced the trimester framework. It basically allowed first trimester abortions, made it very difficult to have third trimester abortions. Essentially, this was really met very quickly thereafter with a sort of backlash. And really, the last 40, 50 years of American history have more or less been a backlash against Roe v. Wade and an attempt to kind of criminalize abortion in all sorts of interesting ways without overturning the decision facially. So that's kind of the legal playing field, and we can talk about some of the specifics. But the more interesting question, I think, is thinking about the morality of abortion. And I'll say that I think abortion is an extremely difficult question. So one of the first questions people have to think about is, are fetuses persons? Now that's a very important linguistic question, persons. I didn't say human beings, I didn't say alive. Those are three different issues, right? Something can be alive but not be a person. Your dog is a good example. You might love your dog, it's a wonderful thing, but it's not a person. Something can be human and potentially not be a person, right? Some people think the early embryo, for example, before 14 days, or stem cells being derived are members of the human species, but may not be persons. So what do we mean by persons? We mean something that has a certain set of moral and or legal rights, the most important of which is a right against inviolability. They can't be killed or destroyed or harmed without very good reason. And we have the attitude that we're all persons, right? So we have an index case, we're pretty clear we're persons. And the question is, who else is a person? Well, to answer that, you need to have a theory about what makes something a person. And there are a few different kinds of theories you can have. One could be just to say, if X is living and a human being, X is a person, right? Now, some people have problems with that. So Peter Singer and some animal rights advocates, for example, think that that's a speciesist attitude, that by saying human equals person, it's problematic that we're excluding animals. Instead, we ought to have some criteria that looks at capacity. So other people have sometimes what are called a capacity X view, where they say, in order to be a person, you have to have X capacity. And then we have to fill in what X is. Is it the ability to think complex thoughts, the ability to plan and look towards the future, the ability to feel pain, whether you understand it? Is it about continuity of an identity over time, or is it merely being alive and breathing? And some people think it's a single criteria, others think it's a compound criteria. And then there are complex questions about what happens for things that have the potential to have capacity X or had capacity X but lost it. So for example, a fetus doesn't have the ability, as early fetus, let's just say an embryo, just to make it very easy, an embryo before 14 days doesn't have the capacity to think deep thoughts about the future, have future orientation. I think that's pretty well accepted by everyone. But it certainly has the potential to do so, right? And the question is that enough? What kind of theory of potentiality? You know, hydrogen and oxygen each have the potential together to become water. But does that mean that they are water? They have the metaphysical properties of water? Or do we require more of a kind of potentiality, something like in the natural course of things, you will become something? The other difficult set of categories are things that once had the capacity, but now no longer have it, and perhaps never will again. So those that are brain dead, for example, are a good example. They are certainly human beings. Most cases, they have been persons. But now if your capacity for personhood, how you define personhood, is something like the capacity to think deep thoughts about the future or to have future orientation, these are entities that no longer have that capacity, and we don't believe will have it again. Do they cease being persons at that point? This is to say that in order to understand whether a fetus or an early embryo, the kind that are used for stem cell derivation, is a person, you have to do a lot of metaphysical work in understanding what makes something a person and why, and what those capacities are. Now, even if you think something is a person, that doesn't necessarily mean you've solved the abortion problem. So it is possible, although popular among philosophers, not so popular in the political press, to say fetuses are persons, and yet abortion is still legal and justified. How does that argument go? The suggestion is that there is a right of another entity that has overcome whatever interest the fetus has. And that is the right typically of the mother who is gestating the fetus. So the claim is, yes, a fetus is a person. Yes, abortion will cause the death of a person, but that doesn't mean that abortion is wrong, because the woman gestating the fetus has a right to stop that gestating, even if it will result in the death of a person. And the most famous version of this argument comes from Judith Jarvis Thomson, a very famous thought experiment about the world's most famous violinist. And she says, imagine you find yourself, you had a heavy night of drinking, you got drunk, you blacked out, and you wake up the next morning and you find yourself a human dialysis machine hooked up to the world's most famous violinist. Nobody doubts the violinist is a person, right? He's not only a person, a great person, world's most famous violinist. But she says, don't you have the right to unplug yourself from that person, even if it will turn out that it will result in the death of the violinist? And she says, if you think the answer is yes, then you think that even though the entity is a person, you may have a right to cause its death, a right to unplug itself. And she analogizes that to the right of a mother to unplug herself from her fetus, who is a person. Now, there's lots of contestation about that thought experiment, right? You might say, you got drunk, no fault of your own, somebody kidnapped you. Is that really the situation of all women who become pregnant? Or is it the situation only of women, for example, who are raped or who are impregnated in an unconscious state? But this is just to show that there's some complexity here. Okay, one more point. That is that the stem cell question looks different on this regard. Remember, when we're talking about embryos, we're talking about embryos that are frozen, that are in a lab. Nobody is gestating them. If embryos have the rights of persons, unlike in the case of abortion, there's nobody who has a contrary right to stop gestating them. So you might actually think the argument for a prohibition against destroying early embryos is easier than the argument for prohibiting abortion for this reason. Now, on the flip side, you might think the early embryos have even less of the capacity X, whatever that is, than does the fetus. But this is the way in which bioethicists and lawyers think about these problems.